right. Well, David, thank you so much. That was awesome.
Thanks, everybody.
Oh, oops. I think, do not notice the man behind me moving the chairs, but I will start to, what I mentioned yesterday is when we've been talking about AI and people investing in it, and it's how it makes things more efficient and easier for you, and you can streamline, but there's also can be some challenges behind it. And so what we have now is our next speaker, which I think he's here. Oh, there he is.
He's wearing a suit. You know he's an attorney. He's wearing a coat.
I want to make sure I get your title correctly so I don't get sued or anything. Gary Kibel. He's the partner at Davis+Gilbert LLP. Come on up, Gary.
He's a veteran.
And do you need this? Nope, you're there.
Okay, thanks very much. Yes, my name is Gary Kibel, and I'm an attorney with a law firm in New York, Davis+Gilbert. We do a tremendous amount of work in the advertising and marketing industry. I co-lead our privacy practice, usually dealing with digital media and data. But AI has become a really huge issue for everyone in the industry. So wanted to talk to you about some of the risks out there. And we're going to pose a lot of questions. We may not have answers to a lot of these things because so much of it is new. So there's me, in case you want to connect with me. I'm not wearing the same shirt from that photo, am I? No, okay, because that's happened multiple times. It's been quite embarrassing. So, as I said, things in this space are changing rapidly. I mean, really every single day, things are different. Talking to people over cocktails last night, we were talking about the deep fakes with Drake and the music. I mean, things are just happening on a daily basis. I think in my privacy world, things were changing rapidly. In AI, it's even faster. So, why don't we start off by talking about using AI in marketing. Here's an example of someone trying to use AI in marketing.
Hey, it's Ryan Reynolds, owner of Mint Mobile. We're always looking for ways to save you money. So this year, we're kicking things off with an ad that I created using ChatGPT, the AI technology. This is what I asked it to write. I said, write a commercial for Mint Mobile in the voice of Ryan Reynolds. Use a joke, a curse word, and let people know that Mint's holiday promo is still going even after the big wireless companies have ended theirs. This is what it wrote. Hey, it's Ryan Reynolds here. Eerie. First of all, let me just say Mint Mobile is the shit. But here's the thing. All the big wireless companies out there are ending their holiday promos, but not Mint Mobile. We're keeping the party going because we're just that damn good. Give Mint Mobile a try. And hey, as an added bonus, if you sign up now, you'll get to hear my voice every time you call customer service. Just kidding, that's not really a thing. And stay classy, everyone. That is mildly terrifying, but compelling.
So it's going to find its way into advertising, and that's kind of a cute way, but there are a lot of risks when you get involved in advertising. So when we're talking about generative AI in the legals context, we're looking sort of at three elements: the training data, the inputs, and the outputs. So the training data. What data is this AI scraping around the internet to learn all the brilliant things that it's going to use to eventually generate the outputs? And the inputs, what is the user asking the AI to do? Are you asking it to create a pretty picture of a sunset, or are you asking it to find people's social security numbers? And then the output. You know, there's not a lot of transparency, especially around the training, about how the AI services are collecting the data to generate the output, and that's creating some problems. So the legal problems that are being created, and welcome to law school now, sorry, copyright, right of publicity, privacy, trademark, and contractual issues. We'll talk a little bit about most of those. And again, we're identifying the problems, and then in your own marketing activities, you need to think about these issues before jumping into any projects, and I'm going to show you some do's and don'ts towards the end. So copyright. What is a copyright? Copyright protects an original work of authorship, a book, a song, a painting, and you get exclusive rights to that work the minute it's created. But the Copyright Office in DC, you don't have to register a copyright, it's automatic, but if you want to sue someone, you have to register it. They've already talked about AI, and they said the office will refuse to register a claim if it determines that a human being did not create the work. They've said very clearly, copyright belongs to a person. A computer, for instance, cannot own a copyright. And you might think, wow, that's a really groundbreaking new decision from the Copyright Office. Not really. It goes back over a decade ago to the monkey photo. Anybody familiar with the monkey photo case? So there was a very famous photographer, David+Gilbert, and he was taking pictures of crested macaque monkeys in Africa. And one of the monkeys grabbed his picture and took a selfie. And it was known as the monkey selfie. And it's an awesome picture, as you can tell. If you Google monkey selfie, you'll see this photo everywhere. Well, Mr. Slater says, hey, that's my photo. I own the copyright to that. So he started sending takedown notices to websites that were putting up the monkey photo. And then the Copyright Office again said that only a human can own a copyright. And this picture was taken by the monkey. So David does not own the copyright. Now, once PETA heard about that, PETA actually sued in California saying the copyright belonged to the monkey. But then a judge says, no, monkeys don't have rights in human courts. So it's an old concept, and think about how it would have applied to some things that have happened previously. There's the very famous painting from Shepard Fairey of President Obama where he put in that image where he was making a transformative photo from a different style. Well, what if that was made with generative AI? Because you don't have really control over the output. You have control over the input, but you have no control over what it spits out. Now, styles are generally not protectable. But, if I said someone made a beautiful painting of a sunset, I can make a beautiful painting of a sunset. Well, I probably can't. I probably can't even finger paint. But technically, I could make the same thing in the same style. But if it gets too close to the line, then it could be infringing. And that's where the inputs can generate unfortunate outputs. If you went to DALL-E 2 and said, I want a painting of a fox sitting in a field at sunrise in the style of Claude Monet, you get this. And it could look really, really close to something that Claude Monet might have painted. Now, fortunately, he's long and gone and his rights may not be around anymore, but you could ask AI to create something that's infringing. And that's happening with trademarks as well. So what are trademarks? Well, you got one of the most famous ones in the world right there. Trademarks are logos, symbols that identify for someone the source of goods or services. So you could go to an AI service and say, I want a monkey drinking a bottle of soda, or I want a photograph of a couple eating in a fast food restaurant, but the output may have trademarks in there. And then you start to use this AI-generated photo, you could be liable for trademark infringement. Again, we don't have control over what the outputs will look like, although you do have control whether or not you use the output. So right of publicity, what is that? So the right of publicity is the right of any person to control the commercial exploitation of their image. You can't decide, this certain celebrity is great, I'm going to put them into my advertisement or my commercial, or I saw them using my product, I'm going to put them into an advertisement or a banner ad or something. You can't do that because that violates their right of publicity, and that's why celebrities make a lot of money through advertising. So right of publicity problems are coming up in AI as well. This was one using the service Midjourney, where the prompt was to make a young man sitting on the couch with headphones on in the style of iconic pop culture references, prairie core, avocado punk. I must be 1,000 years old, so I don't know what half of this means. Photo taken with Kodak Portra, Garden State, intense gaze, modular movie still. And it shoots out this guy. Now, if this guy looks really close to a celebrity, then the celebrity may have a claim, even though you didn't use an actual picture of the celebrity. It's those dangerous outputs that you might end up with. So it's the big question, who's liable? Who's liable when this goes wrong? Are the platforms liable because they're the ones who are generating the output? Or is it the user who's liable because you're the one who put in the input? And I'll talk about OpenAI's terms of service in a moment, but there's not a lot of answers here about who's liable. I think it's potential, just my own personal view, is that both can be liable. If the service automatically generates something that's infringing, I could see an intellectual property owner going against the service provider and suing them. But if you as a user asked the service to create something that would ultimately be infringing, said, give me a photo of, a female artist, who looks like, Taylor Swift, and then you got that and used that, I think you would be liable for a right of publicity violation for asking the AI to create that. So, contracts. Contracts drive everything in business. We all have contracts out there. And think about yourself as maybe an ad agency working for a brand. And the contract says everything that we create for the brand will be original, and the brand will own everything we create. Well, now the agency goes and starts using AI to create things. So firstly, it's not original. They didn't create it. A computer created it. And ownership. Who can really own it? If it's something that's infringing, is it really owned by the brand or not? And then the agency may be on the hook to indemnify the brand if there's an infringement claim. So I've seen a lot of clients that are getting into AI projects are putting little addenda together or writing something on the statement of work, in obviously it'd be more legalese and artful, but basically saying, look, we're using AI, all bets are off. I don't know if you own it, I don't know if it's infringing, but we've agreed I'm going to use AI in this campaign. And it's really that thought before jumping into an AI campaign that's really important for both parties. SAG and AFTRA for talent agreements have jumped in this because they're worried about deep fakes are being used to avoid using the actual celebrity. And their concern is that if you're evading the requirements of the SAG commercial contracts, then you're not paying into the pension and health fund when you hire a celebrity to be in an advertisement or a commercial. So what are the things we can do? We all know there's lots of things. You can create copy. You can use it to really manipulate SEO. You can do it for market research. You could do it for creating content. There was some article I read that said maybe 90% of the content online within 5 years is going to be AI generated as opposed to created by humans. There's certainly a lot you can do. And some brands have gotten into the act already. Coca-Cola had this Create Real Magic campaign where they released authorized Coca-Cola branding elements and encouraged people to use DALL-E to create artwork using the authorized elements. So Coca-Cola gave certain inputs, but then they allowed the users to use additional inputs, and the outputs, who knows what they could be. And there were lots of interesting outputs, and I don't know, some of these may be very similar to someone else's work of art, because you don't know how DALL-E scraped the internet to create this. Again, using the Coca-Cola authorized branding elements, but the outputs are not just the Coca-Cola logo. There's many other elements in all of those pictures there. So, some do's and don'ts to help you here. Do, be transparent with clients about an agency's decision to use AI-generated content. I put that in an agency brand context, but it's really in any relationship. Be very transparent. Do not use AI without telling your partner you're using AI. Make sure the AI platform's terms of service allow for the commercial use of the output, and I'll show you some terms of service in a moment. And use generic prompts for style descriptors. Again, don't say, I want a picture that looks like Taylor Swift. Say something a little bit more generic. Don't say, I want, a movie star that looks like Tom Cruise. Again, use something a little bit more generic. And then, when you get that output, don't run off to the races and start using it immediately. Look at it. Think about it. Are there any issues that might be with this output? Not saying you have to run it all by your lawyers, but you could talk to your lawyers. That's a helpful thing to do as well. What not to do. Don't include references to pre-existing copyright works, trademarks, individual names in text prompts unless rights have already been cleared. Now, I would say legally by using someone's name or IP in the prompt, that in and of itself may not generate the claim, but you're telling the AI, give me output that might generate a claim. Don't upload pre-existing visual references to a prompt unless you own or control the rights to those references, and don't input any confidential or personal information into the AI. So privacy, my favorite topic, and those who've heard me speak at other events, that's what I do in my sleep, speaking about privacy all the time. The privacy laws are trying to figure out how AI works. Some of you heard me speak before about the CCPA, the California Consumer Privacy Act. Apparently, according to my marketing department, I'm supposed to add text in that first bullet point, which I guess I'll do after the conference. But there are these existing laws about privacy. In Canada, there's a proposed bill that would deal specifically with AI. The European Union has categorized AI as a high-risk activity which requires additional analysis. And Italy has outright banned ChatGPT. I don't know how they can stop people from using it. There's no like the Great Wall of China version in Italy, but they have said that it's illegal to use it because of the massive collection and storage of personal data. And there's no legal basis for for ChatGPT to be gathering and transmitting all this personal data and shipping it from the EU out to the US. So that's created some problems. One agency in Italy had to really stop their activities because the Italian regulators have said you can't use this generative AI platform because it's violating our privacy laws. So again, we got the copyright problems, the trademark problems, the right of publicity problems, and the privacy problems. Again, as I said at the beginning, lots of questions, not tons of answers. Getting towards the end here, but I want to leave a little bit of time for questions. So as a lawyer, I jump into the terms and conditions because I want to know, what do they say? What do these platforms actually say to you? OpenAI's terms they're kind of thin, but not too bad, although they're dancing around issues. So forgive me for reading everything here, but it's important. They say, you may provide input to the services and receive output generated and returned by the services based on the input. As between the parties, and to the extent permitted by applicable law, you own all input. All right, so they're saying, between you and me, and if law allows you to own it, it's yours. They're not confirming that you own the input, because who knows what you're actually going to input. And then OpenAI hereby assigns to you all of its rights, title, and interest in and to the output. Little lawyer weasel words there. They're assigning their rights to the output to you. They may not have any rights to assign to you. They're basically saying, if we own something, it's now yours. Good luck. This means you can use content for any purpose, including commercial purposes such as sale or publication. You are responsible for content, including for ensuring that it does not violate any applicable law or these terms. Due to the nature of machine learning, output may not be unique across users, and the services may generate the same or similar output for OpenAI or a third party. So if I was drafting it, I might have taken the same approach to say, look, if we own anything, it's yours. But we're not telling you that what we've given you is unique or that you're not going to have problems in the future when you use this content. So what is the federal government doing about AI? And I was just reading an article before I get to the federal government this morning. A California lawmaker proposed an AI law, I think yesterday, to regulate the use of artificial intelligence. And they realize in their statement is that AI use is growing so quickly, there are no legal controls. A lot of them are concerned about, and this came in to a lot of things with data and privacy, about unintended negative consequences. This comes up in the privacy and data world where maybe the use of online data will generate offers and ads that exclude certain disadvantaged groups. And it's not intentional discrimination, but the data is creating discrimination. And I think that's a concern in AI as well, that there may be these unintended negative consequences from AI. But we don't have any laws in the US yet that deal directly with AI. So jumping to the right there, the first thing, the only thing our Federal Trade Commission can really enforce is deceptive or unfair practices. This is what they use for everything, for advertising, for privacy and data and security. If you have a privacy policy that says you don't sell information to a third party, but you do, that's deception. If you had a television commercial that said the car goes 0 to 60 in 5 seconds, but it takes 10 seconds, that's also deception. It's this very, very broad deception and unfairness power the FTC has. That's all they can enforce, but it is a very, very broad power. So they issue statements, and it's important to pay attention to these statements. So they said in a blog post that the term AI can be used as a deceptive selling point for new products and services. So don't tell people that, hey, we created this with AI because you want to sound cool, if that's not the case. And then the flip side, with chatbots and deep fakes and voice clones, that's deception the other way. You're not telling someone that you did use AI to create something. And actually, with chatbots, there actually is one interesting California law about disclosing the use of chatbots. So this all comes down to just being transparent with your business partners and with your consumers so that nobody's confused about how you arrived at this product or service. Lawsuits, they're starting to happen already. Getty Images has sued a whole bunch of AI platforms, and they're alleging everything. They're alleging copyright infringement because the training data is scraping images all around the internet. Trademark infringement because the algorithm copies and may incorporate elements of logos in those photos, and a violation of the artist's right of publicity by categorizing the artworks with the individual's name and artist. So the lawsuits are already starting to happen. This one's not really AI, but just to show you that all new technologies, you run ahead with it, and then you don't realize there could be an intellectual property problem. Hermes won this lawsuit over an NFT, that someone created an NFT over one of their bags. And Hermes says, you're using our intellectual property to generate that NFT. So you have to be careful. So I kind of wanted to leave you guys, and I'll hopefully take a couple of questions if we have time, with one last thing. I wanted to give you some great advice going forward, what you should do. So when I was thinking about how to come up with great advice, I got a great idea. Why don't I ask ChatGPT what I should tell everybody? So I said, if you were Gary Kibel, what would you tell attendees of a Media Post Summit about using generative AI in marketing and work in a reference to golf? Because I'm a golfer. So let's see what it said. Well, as Gary Kibel, I would say that using generative AI in marketing is like playing around a golf. You need to start with a solid foundation, carefully choose your approach, and be prepared to adopt your strategy based on the results you achieve. In golf, you need to have a strong understanding of the fundamentals such as grip, stance, and swing mechanics. Similarly, in using generative AI in marketing, you need to have a clear understanding of the data and inputs that are being fed into the algorithm, as well as the audience that you are targeting. This is really good. Just as golfers carefully select their club based on the distance and obstacles they face on the course, marketers need to carefully choose their approach when using generative AI in marketing. This means selecting the right algorithm, training data, and being prepared to adjust your strategy based on the results you achieve. Finally, in golf, you need to be able to adapt your strategy based on changing conditions on the course, such as wind, rain, or other hazards. Similarly, when using generative AI in marketing, you need to be prepared to adjust your strategy based on changes in consumer behavior, market conditions, or other external factors. By following these principles, marketers can use generative AI in a way that enhances the effectiveness of their campaigns and drives business results, just as a golfer can use the right strategy to navigate the course and come out on top. Well, what does this tell you? You didn't really need to invite me here to this conference. All you need to do is plug the question into ChatGPT. But that's it. Hopefully you got some helpful nuggets there, and I'm happy to answer questions if we have time.
First of all, that was awesome, Gary. Thank you.
Hi, Brian Shepard, Ground Truth. That was great. Can you talk about the financial, so how do you determine what I don't know, does it a court, does a jury would reward and how they value? Because I know a lot of times when you sue somebody, you have to prove that you've lost something, right? So it's a big kind of cloudy subject matter, right? So can you talk about the financial implications?
Sure, that's a great point, because each different intellectual property right has a different way of dealing with it. With copyright, there are what's called statutory damages that are set by by law in the United States, and those can be anywhere from $750, I think up to $150,000 for a registered copyright. You can get those statutory damages or actual damages, and actual damages could be high if it's a valuable photo. For right of publicity claims, that can sometimes be a percentage of profits. It can be based on what did this use of my image do for your brand. Again, rip some celebrity's famous image, put it on your advertisement, that might really help your brand generate a lot of income. So it could be a percentage of profits. So it depends on what type of claim is being alleged.
Anyone else? Oh. Didn't get my exercise today yet anyway.
Hi, Gary.
Hi.
Hub Hardiman with Marigold. You said something earlier about originality. I forget exactly what the comment was, but I was curious about how, from a legal perspective, something out of ChatGPT, something AI generated, is not considered originality, I guess, because it's not derived from a human?
Yeah, so there's sort of two issues there, and I'll go the latter part first. In terms of ownership of a copyright, according to the Copyright Office in the US, only a human can create something that's protectable by copyright. So computer creates it, it can't be protectable. But in terms of copyright infringement, it's sort of a fine line. Like with patents, patents are exclusive, and there is a very bright line. You use my patent, you're infringing. With copyright, there's a fine line. Again, using the example, I paint a beautiful picture of Palmetto Dunes golf course. I own the copyright in that painting. That doesn't mean nobody else can ever create a painting of the Palmetto Dunes golf course. Somebody else can do it, but they can't copy mine. It's got to be different. So it's not a very fine line. So with the generative AI, when they're spitting out something that, if it were created by a human, would be protectable by copyright, and it looks like something else, it could be infringing or it could not. It's a really fine line about where it crosses the line from being in the style, which is not protectable, to where it's copying actual elements and being protectable.
Anyone else? All right, well, Gary, thank you so much. That was great.
Sure.
John?
That's it? No. I don't want to go. All right. Well, we had a good one. It was a good time. Everyone, I hope, had a exciting experience over the last couple of days. Met some good people. Had some fun activities. The weather held for us, which was pretty awesome. Again, my job here is just to thank you all for coming. We had awesome content. I thought it was interesting. A lot of different dynamic speakers and some pretty cool stuff to take home. So, and on top of that, I hope you made some great connections and you'll join us again. We'll be back with this particular Brand Insider Summit Retail in Lake Tahoe, August 20th to the 23rd. So mark your calendars. If you have ideas and you want to pitch them to Lisa right here for content sessions next time around. If you want to return as a VIP, let Kevin know. Where's Kevin? There's Kevin right in the middle, right there. I do want to just, I kind of tried this last night, but I failed. But I just want to thank the MediaPost staff, of which, we wouldn't be here without that. So it starts with Ryan Lochner back there on AV. Thanks, Ryan. You're the man. Yep. Kevin Massa, who you know, Seth Earlman, our Chief Revenue Officer back there, he's the man. Jamie, Delaney, Maddie, John Higgins, they're all out front. Thank you so much, everybody. Can you hear us, guys? Yep. And of course, the great and wonderful Lisa Singer. Thank you so much. I'm sure I forgot somebody. But yep, all good. But and all the sponsors you see right here, thank you so much. We can't do it without you. And we'll see you guys in Tahoe. And Lisa, why don't you give us your parting remarks? Anything? You've been turned off. Here.
Now.
Oh, there you go. There you go.
No, just as you guys are awesome. This is such a great group, and I really, love getting to know you guys, and I appreciate that you ask questions and engage, and it's just been really lovely. So thank you so much. I love meeting all of you.
That's right. All right. Thanks, you guys. Safe travels. We'll see you next time. See you in August in Tahoe.
You got